Welcome to EU Privacy for All, Session 58 on GDPR, Suspension of Proceedings, Article 76a. It was EU Council suggesting for the first time the addition of Article 76a. Most of the drafting. In its final draft, the article retains EU Council proposal, where a competent court of a member state has information on proceedings concerning the same subject matter, the same processing, and the same controller or processor, pending in a court in another member state, it shall contact that court in the other member state initially referred to confirm the existence of such proceedings. In such a case, as regards processing of the same controller or processor pending in a court initially referred to, any competent court other than the court first sized may suspend its processing. It's not an obligation, and it's not shall, but just may. Where these proceedings are pending at first instance, any court other than the court first sized may also, on the application of one of the parties, decline jurisdiction if the court first sized has jurisdiction over the actions in question and its law permits the consolidation. A key provision is provided in Recital 113. It basically lays down the same provisions as in Article 76a, adding in the end that proceedings are deemed to be related where they are so closely connected that it is expedient to hear and determine them together to avoid the risk of irreconcilable judgments resulting from separate proceedings. Currently, the directive does not lay down any provision on the suspension of proceedings. What should accountable data controllers and processors get prepared for? First, knowing that a case being proceeded concerning one same subject matter and one processing of the same controller or processor in the court of one member state may be suspended if a proceeding was already triggered in another member state. This is optional, and may wording makes really clear that this is not mandatory. On the contrary, the court in which the latest case was introduced, having information on the possibility that a case is pending, has the obligation to contact that court in the other member state to confirm or not the existence of such initial and pending proceeding. Let's insist on the fact that there is no certainty on a competent court suspending its proceedings. Any court other than the court first sized may also decline jurisdiction if the court first sized has jurisdiction over the actions in question. Declining jurisdiction would then result from the application of one of the parties. Proceedings are deemed to be related where they are so closely connected that the risk of irreconcilable judgments resulting from separate proceedings needs to be addressed. So the question triggered now is knowing how information will be efficiently circulated from the courts of a member state to another one.